The law of intestacy or intestate is a law that's written into the laws of the different states of Australia, which says what will happen with your assets in the event that you do die without a will. Firstly, if you're married or in a spousal de facto relationship and you do or don't have children from that relationship only, then your spouse will receive not children, but your spouse, so your husband or wife or de facto partner will receive your whole estate if you die without a will. It gets more complicated though, because if you are married or have a de facto partner and you have children from a previous relationship, married or not, then there'll be a split of your estate. So everything won't just go to your spouse or any children even from your current relationship. Any children from your past relationship would also receive money, and a little bit less than your current spouse. But if you die without a spouse at all and you have children, your children will receive everything. If you have no children and no spouse, then your parents will receive everything. If you have no children, no spouse, and no parents, your siblings will receive everything. Or if everybody that I've just mentioned has passed away before you, then your grandparents will receive everything. Or if they've also passed away, your aunts and uncles will receive everything. If everyone, including your aunts and uncles, has passed away, your first cousins will. If you've passed away and you have no cousins, no aunts and uncles, no grandparents, no siblings, no parents, the state that you live in will receive everything. Now, what I mean by this is the formal requirements. So the things you have to have in a will to make sure that the will is actually valid. So the first is that the will needs to be in writing. Now, that might sound silly because most people would think, well, what's a will if it's not in writing? But you'd be amazed, right? People might leave a voice message on WhatsApp to their spouse about what they want to do when they die because they realize that they may not have long left. There may be a conversation where you say, I'm going to give everything to you when I die. That's not a valid will. It needs to be in writing, and it needs to be signed by the person making the will. So with their signature, not like DocuSign or e-signature, but a physically signed document. And it has to be with the intention of making the will. So in other words, you actually have to sign it knowing that by signing, you are making a legally binding document, a document that will bind people, other people, when you pass away. So if you sign something that you think might just be a draft, or you sign it not even realizing, for example, that it's your will, which can happen because people have been tricked, then it won't be a valid will. And finally, the will needs to be signed on every page. But not only that, two different witnesses, and preferably not people who are mentioned in the will, two other people need to sign next to your signature on every single page of the will. So if those things are not there, those four requirements are not all satisfied, then your will won't be a binding will. It won't be a valid will under Australian law. It's important, and it can impact people at all ages, but I see this a lot with elderly members of our community. People will make a will, often because they're very worried about they may be quite sick or towards the later years of their life, but they're not able to, for example, remember facts or have rational understanding about their financial position or understand even the legal consequences of making a will. There have been a lot of legal cases in a lot of courts all over Australia where people have made wills and then their family has said, no, that person was unable to make a will. They weren't able to remember. They might have had severe dementia, for example. That would mean that person did not have capacity to make a will. And I suggest seeing a lawyer is because lawyers are trained to make sure that anyone who makes a will is able to properly understand what they're doing. I think any time is a good time to prepare a will. Often people will find if they have children or their first child or more children, that's a good time to draft a will because you have then responsibilities to the next generation. If you buy an asset, like buy your home, for example, that might be a good time to make a will. But really, I think there's no good time. I think any adult should be thinking about making a will sooner rather than later in their lives. I hate to say it, but most people don't until they're very old and often run into those capacity issues I was mentioning. Yes, short answer is yes. It's a bit more complicated, but that's possible. Firstly, you can leave assets to foreign people who don't live in Australia. So if you have assets in Australia that you want to leave to someone who's overseas, you can do that. There may be some tricky legal issues about putting, for example, a property in their name, because if it's an investment property, it needs approval of the Australian Foreign Investment Review Board. So that can be tricky. But if a person is living overseas and they're left out of a will, then they can challenge the will. Just because they're overseas, it is harder, obviously, because somebody who's living in a different country trying to deal with something in an Australian court, but it's possible. The one thing that's important to understand, if you have assets in your home country, wherever that is, often people do, they leave either as a refugee or otherwise, go to a different country like Australia, but you leave assets in your home country. I would strongly recommend that you make a will in that country as well. So you can have an Australian will, but it's not absolutely necessary, but it's actually a lot trickier and it won't always work if you try and make a will in Australia, for example, and then leave assets in Greece to somebody under your Australian will. There's an international convention, like a law that applies, that binds a lot of countries, not every country, that says that different wills can apply, but different laws are in different countries, right? So it's important to make sure that the will that you make in each country for anywhere you own assets deals with those laws and addresses those laws and complies with them. You can't put it in the cloud because you need the original. It's very hard to deal with circumstances where there's no original will. My suggestion always is keep it with a lawyer or in a safe, somewhere where it will never move, where it will be protected, and make sure you tell your executors where it is, and do it in an email. So if that executor forgets, they can look at the email later.
A will cannot be in a digital copy. It needs to be in a physical copy.
Yes. So when you go to the court to get the order allowing the executor to deal with your will, the court makes you provide an original copy. If it's lost, you have to prove. It's a much more difficult process. No, you don't have to be an Australian citizen to make an Australian will. In the same way, you could be an Australian citizen and make a will in Greece. If you have anything in Australia that's capable of being left in a will, or even if you don't, you can make an Australian will. It doesn't matter whether you're a citizen or temporary resident. There may be tax implications in foreign countries, for example. If you have beneficiaries in England who receive part of your estate in England, about 40% of that goes to the English government straight away, even if you make an Australian will.
A will made in Australia, is that recognised globally?
Possibly. So again, it needs to be recognised by that international treaty. It's best to avoid having a situation where you have one will trying to operate in other countries outside. If you've got assets in other countries, make a will in that country, because there's no guarantee that it will be recognised, because that country might not be a party to the treaty. And even if that is a party to the treaty, there might be a technical issue in the will that means it's valid in Australia, but not actually valid in the other country.